Hello, reptile entrepreneurs. This is your host, Bill Strand. Today, we have a return visit from Richard Clark, our patent attorney. He's coming to talk to us about trademarks. What are they, and how do we use them to protect our business? Please join me in welcoming Richard Clark back to the podcast. Welcome, reptile entrepreneurs. This is Bill Strand, and we are back for part 2 with Richard Clark, who is a patent attorney. And today we're going to be talking about trademarks. Richard, welcome back to the podcast.
Hi, thanks for having me, Bill.
All right, so we talked about patents last time. Today is trademarks. So let's just start off. What is a trademark and what is trademarkable?
Okay, Bill. A trademark is either words, a logo, or a slogan that you use in connection with promoting goods or services. Let me give you a really good example. Allstate sells insurance services. They have a 3-part trademark. They have the word Allstate Insurance, which has been protected. They have the 2 hands cupped as a logo in a circle. And then they have the slogan below that, "You're in good hands."
Okay.
All 3 of those are trademarks, separable or as a composite mark, and they're protectable, and no one can infringe those marks and sell similar or related services. For example, go into the insurance business. So
Okay.
Allstate has it covered.
Now, you said similar products. Can somebody selling fish ponds use something similar?
Yes, they can. Let me explain. For every trademark filed for federal protection, there are 45 categories of goods and services. For example, if you're going to trademark a beer, you would be in a specific class. If you were going to trademark security services, you'd be in an entirely different class.
Okay.
So the trademarks that are filed have to be similar in sight, sound, and meaning, and also they have to be related or similar goods or services in order to be trademarked or rejected by the trademark office. Let me give you an example. I could not trademark the word Apple for any type of electronics right now. Apple is a computer company, and they also make iPods and iPads and all kinds of other electronics. So I would absolutely be refused for that. But if I were selling brooms, I could label them Apple. Apple brooms. I could sell Apple cars. I mean, maybe not cars. I don't know, because the Apple may have self-driving cars now or in the future. So you get the idea. In other words, I could use a common word like Allstate, but I would have to stay away from insurance services, security services, banking services, anything related to financing or insurance. But I could call my farm Allstate Farms, and I could sell pork. Mm-hmm.
And so the words, "you're in good hands," what is trademarked on that? Is it the words or the appearance of those words, as in the font and the color and such?
It's the words, Bill. So let's go over it again. A trademark can consist of 1 or more elements. The first is the word. Okay, the word mark is Allstate. The second is any kind of a logo that you put together. For example, the AT&T Globe or the Nike swoosh. That's the logo.
Okay.
And the third is a slogan. The original this, or since 1953, or since you're in good hands, or I'm trying to think of some other slogans that are out there that become
"Just do it."
Just do it. Perfect, Bill. Perfect. Okay. So the trademark can be 1 or more of those elements put together, or you could trademark each individually so that when people see that mark in conjunction with the connection of the goods or services, they will relate to that, the source, the reputation of the company.
Okay. And how hard is it to get a trademark?
Well, the process is, I would say, not very difficult, but there are so many marks already protected out there that the most important thing is to be creative. And you want, I tell my clients, you want a mark that has marketing sizzle. You want something that's exciting. You want something that looks good or sounds good. If you tried to trademark the pet rock, I mean it's unique, but it doesn't have a lot of excitement surrounding it.
Okay.
And also it's good to be descriptive. So in the beginning, you've got to be creative. You've got to find a mark that you really like, but don't stop there. I tell all clients, don't get married to one single mark. When you come to me to do a trademark search, I will search 3 marks because usually the first one or the second one is not available because someone also has it. Not all trademarks that have been registered are in commercial exploitation right now. They're just on reserve, some of them, some, not all of them are used, but you still can't get a trademark if someone else has done it before you.
Okay. Well, how important is it to do a trademark? And the perspective that I'm coming from is, say, those of us in we're solo entrepreneurs and we make up a drawing and we put together the name of our company, and that's our logo, something we put together ourselves. At what point is it important to trademark that?
Well, it's important for a couple of reasons, and I'll make 2 points here. The first point is if you're going to move forward and build your business, you're not going to want people to come along after and try to fool the public that they're selling what you're selling. So a trademark can become very important. For example, your house mark might be your company name, like Ford Motor Company. That's called a house mark. It's a trademark as well, but it covers many trademarks under it. For example, the Ford Bronco or the Ford Taurus. Those are trademarks for specific products that the house mark Ford Motor Company sells. So if you're going to move forward and build a business and you don't want people to come in later and try to fool the public, I have the same thing and our name is the same, and they ride on your marketing dollar coattails, you should trademark your image. Your corporate image, either as a house mark or as individual product marks or both. And the other reason you might want to do that is a lot of people build companies for the purpose of selling them to a larger company or merging with a larger company. And before that merger or acquisition takes place, they're going to want to see that you've protected your trademarks. They're going to want to see that you've protected your name, even if they change them later. If they buy your company, they want that built-in protection. And each time you get a trademark, you increase the value of your company more than 1 million-fold.
Okay. So getting into how we make our logos and such, many of us will go to the computer and there's all sorts of fonts available, Arial, Times New Roman and such. And we make a logo using one of those fonts. How does that affect the ability to trademark?
Well, like I said, there are 3 types of trademarks. If you're doing a word mark, if you're just doing your words, it has to be in no particular font. You're protecting the words in any font. If you're doing a stylized logo, with a really stylized font, like Fiery Brewery or whatever, and you've got flames and you've got red and it goes from big to small. like a flame itself, then you would want a design graphic person to do that for you. Or if you're talented in that regard, you can do it yourself. And that image would be protected. As far as the slogan goes, if you wanted to put it in a special font, if it were related to that special logo, then you would use any font you want, and it would be protected in all fonts. So again, the words and the slogans are protected no matter what font they're in, but the logo is protected with regard to its stylized look and also possibly color as well.
Okay, so even if a logo uses a standard font, you can still trademark it.
Correct.
Okay.
Right. Because that would be the word part of the overall trademark, the composite trademark.
Okay. And what is the process for getting a trademark?
Okay, I alluded to this earlier. You've got to be creative. I mean, you've got to, a lot of my clients will write down their 10 favorite possible trademarks. And then they will take them to family members or coworkers or people outside of the industry, and they will do a kind of a market analysis or market research and say, which one do you like the best? And they'll narrow it down to 3. And this is what I tell them: come to me with 3. Because when I do a trademark search, I'll search 3, and they should be slightly different. They actually should be different, because if I search one and the next one is just a plural of that one, I've already knocked it out if I've knocked out the first one. So they should be very different. The first one should be ABC, the second one should be EFG, and the third one should be XYZ. They should be that different. And then go to a trademark attorney and say, hey, which one of these do you like? And would you search all 3 of these and tell me which one of these do you think I have a high probability of getting registered? And then we would do the search, and we would do the report and the analysis. And then if your first choice is clear, we would go ahead and file a trademark application. Now, that application would have to be either a use-based application, which means you're already using that mark in interstate commerce between federal or state boundaries, or it could be on the reservation system, which is called an intent to use based trademark application. And you would have to sign an affidavit when you file it with the U.S. government, with the U.S. Trademark Office, that states that you have a bona fide intent to use this trademark in connection with these products or services within the next 3 years. So you can reserve it for up to 3 years. I normally recommend that they somehow start using it and you have a use-based trademark application, because an intent to use application, or what we call an ITU, takes a statement of use later after you start using it, so it costs a little bit more. It's better to go with a mark that's open and start using it, and then apply for it the day you start using it, the week after, the day after, the month after, but very close on to the date that you start using it in interstate commerce.
Okay.
And then we would file the trademark application.
And how do they judge how, if your application is too close to another one?
Well, that judgment starts with your trademark attorney. And so I will tell you, don't file it, it's too close, or let's file it, I think we can get it through. And a lot of times the examiners will throw something up and say, hey, you're too similar to this. And we'll have to prosecute that application, which means I'll have to write back arguments why the examiner is wrong. This is very common. They don't all go straight through. If you do a good search and you have a really creative mark, it'll go straight through. But if it's kind of close, maybe a little bit close in services or goods or sight, sound, or meaning, it may get rejected. Let me just say this. You're not going to be able to federally register your new restaurant if you call it the Crazy Chicken, because in sight, sound, and meaning, we already have El Pollo Loco out there, and they've got trademarks, and that's the meaning part of it. You also can't file for some telecommunication services and have anything that looks like the AT&T Globe as your mark. Even if you put another word or another slogan with it, it's too close. And that's in sight. And that's in meaning. And then in sound, you can't just put an S at the end of it. So you can't say Nikes or Nike XL or something like that, because it's too close in sound. I mean, that's the main word of the mark. So we go through that. We try to make the prosecution as minimal as possible, but it could happen. And we have to fight for your trademark in some instances.
Okay. And what is the proper usage for the TM and the R?
Excellent question. Excellent question. So when you adopt a mark and you start using it, whether you're using it on a website or on a brochure or at a trade show or out in public, selling it on the product themselves, if you haven't got a registration, you need to use the TM symbol. The TM means I'm using this as a trademark. I'm using this mark, this word, this logo, this slogan, or all three together in a composite mark as a trademark. So it puts people on notice that I'm using it as a trademark. You cannot use the R in the circle, which stands for registered trademark, until we actually get the registration mailed to you and you have it in your hand, or I have it in my office. Then you can convert to the R in the circle, which means this trademark is registered. So the difference is, the first one, the TM, is I'm using it as a trademark, no trespassing. Mm-hmm. The second one is I've registered this trademark, keep out. It's very different.
So say you have a TM after your logo that you put together. Is anybody going to, what does that do for you if somebody is applying for a trademark for something that's pretty similar?
Okay. It boils down to this. When you start using a trademark, you have what's called priority of use. So in the beginning, if you have adopted a trademark, you should use it right away, as soon as possible in interstate commerce, because that's when your trademark rights begin. Okay. You can't hold on to it and say, hey, I'm going to do it 5 years from now. Somebody else comes in with something similar, you're not going to get your trademark registered. So priority of use is number one, and it's very, very important. It's also important to do a full search, a full trademark search with a trademark attorney, or on your own online if you're good enough to do it, to find out if anybody's got anything similar in sight, sound, and meaning and in related goods or services, because you're probably not going to get it, even if they haven't registered it yet. If they've already started using it, you're not likely to get it. And they can come back and complain that you got a trademark when they were using it before you in what's called the cancellation process. So if they're a sophisticated company, they'll see that you got a trademark after their priority date of use, and they can knock you out, even if you've gone through it and got it registered by an oversight of the U.S. Trademark Office.
And you say knock you out. If who is actually going to come to your door and say, you better stop?
Well, once you file a trademark application and it gets allowed, it gets published for what is called opposition. And a lot of the big companies and a lot of trademark attorneys are watching the published marks to see if anybody's trying to get anything similar. And if they object to your getting the registration, they can start an opposition proceeding and knock your trademark registration out, which means you'll never get it registered. If you got it through and you got it registered and they learn about it later, they can file a similar objection called a cancellation of a registered trademark. And all they have to do is go to the trademark office and prove that they were using something similar for similar or related goods before your date of first use, or your date, if it's an ITU, of filing, which is a constructive date of first use.
Okay. And how long does it take to go through the process?
Okay, once you come up with 3 names, I can do a search within 7 to 10 days and give you a report on which is the best, or tell you come up with 3 more.
Okay.
I hate to do that, but sometimes it happens. Then to prepare and file the trademark application takes within 1 to 2 weeks. We have to get specimens of use together, dates of first use, who's the owner, and we'll talk about ownership in a minute. And then we put the logo or the slogan or the words together or separately. And sometimes I may tell a client to file more than 1 trademark application to protect these things separately, or they can file one that protects all 3 together. Then we file. Okay, so now we're 10 days, 2 weeks, we're 3 weeks out, let's say. It takes 4 to 5 months for the trademark application to get picked up by a U.S. Trademark Office examiner, looked at, and they will send an office action back. Now, sometimes if we did our homework properly, that office action will be a notice of allowance or a notice of publication, which means they will publish it for that opposition period. If not, if they feel something's too close, they'll send back a rejection letter, or they'll send back a letter to clarify the goods or clarify the recitation of services. And we'll have to file an amendment and a response to that. And they will give us 6 months to file that. Normally, the client will decide quickly, we'll file it quickly, and then if everything is in order, we'll get a notice of allowance, it'll get published for opposition, and we'll get the trademark registration certificate in due course. The whole process takes about a year to a year and a half.
Okay. And is it, would I be correct? I wouldn't even make assumptions here. But with a patent, I have to do a patent application within a year of first use. Is there any such limitation with trademarks?
No, there isn't. Once you start using a trademark, especially in interstate commerce, but even locally, you start accruing what are called common law trademark rights. And they're limited rights, and they have to be adjudicated in a state court, not a federal court. So one of the best reasons to get a federal trademark registration is because it opens up more avenues of protection for you over and above a common law trademark right. Common law trademark rights are not very powerful. Federal trademark rights are extremely and the most powerful rights that you can get. So you can have a trademark and you could use it for years and years and years, and you have common law rights accruing. But if you don't register it, you can never take it to federal court.
Okay. Okay. And say I get a trademark and somebody is making something that violates my trademark. What's my what's my remedy? What is the only thing I can do is to pay a bunch of money to the legal system to tell them to stop?
No, not necessarily. The first thing I recommend the client do would be to go to the trademark attorney that they worked with, or find a good trademark attorney and get an analysis of whether or not it's truly trademark infringement.
Okay.
If it is, what I recommend the client do is send a friendly letter first, business to business, not attorney to business or attorney to attorney. and say, hey, we noticed your trademark out there. Did you know we have this registration? Did you know we've been using it for similar or related goods or services since 1983? Did you know, that we have counsel, and would you like to voluntarily stop using it? Because you're confusing the public. And normally, if they're a sophisticated other company or individual, they will see the writing on the wall at that point and change their name. They will agree to stop using it. They may ask you if they could get a license, but trademark licenses are much more complicated than patent licenses. And I can get into that in a minute. If that business to business letter doesn't work, then you want your trademark attorney to send what's called a cease and desist letter. And I do a lot of them. And I'll send a letter to this person and I'll say, hey, absolutely, my client has spent all this money, all this effort, and all this time protecting his trademarks, and he's not going to acquiesce in his trademark rights, and he's not going to let you continue. You need to stop using the mark for these goods or these services, or we're going to take you to court.
And what are some examples of that? Trademarks are a representation of the company. And so you wouldn't want to be confused with another company that has a similar logo. So is this a case of who has to change their logo?
Yeah, it would be a case. Let's simplify it. Let's just say the name of your company is Dragon Strand, right?
Yep.
Okay. Let's say somebody came out, it doesn't matter where, with a huge website and a huge wholesale retail operation, and they called it Dragon Reptiles.
Okay.
Okay. You wouldn't be happy with that if they were directly competing with you. So you would send them a letter and you would say, hey, I've been using this mark for years. I've got a registration. I've got common law rights. I need you to stop using it. And if they didn't, then you would come to me and we would send them a cease and desist letter, or we would threaten them with litigation, and we would ask for arbitration mediation before we, file any kind of a lawsuit. And usually they will have to stop because that's too close. Okay. Using the same word dragon for, the same type of goods and services would just confuse the public completely.
Okay.
So they wouldn't be able to tell which is which company has the reputation, which is the source of the goods or services that they were allowing. And so you would have to protect your mark in that regard. I don't know if that answers your question. Ask me again.
Yeah, I was just trying to figure out the scenario that you would actually have two people trying to fight over the same mark. Mm-hmm. And the only one I could come up with is if they were both developing this company in parallel, maybe unaware of the other, and then they suddenly find themselves in a confusing situation.
Yeah.
Because you wouldn't want to have a name similar to another company unless you were trying to siphon off their customers, which that's an obvious situation. But
right.
Otherwise, you wouldn't want to have a confusing trademark.
Right. Yeah. And that's why you do a search in the beginning before you name your product or your company. And, when you get a corporation or an LLC formed in whatever state you're in, they do a full search too to see if there are any names that are confusingly similar. I mean, you can't get, if there's Sunshine Realty, you can't get Sunset Realty. I mean, it's too close, they won't let you form that LLC. Okay. So, in most cases, in a state like California, they're very strict about that, because they don't want people riding on the coattails of other people's marketing dollars. But I would recommend that if you have a long-standing name in any business, that you get a trademark for it, just in case somebody else comes out and tries to fool the public about where the products are coming from, where the services are coming from. It goes a long way also to the value of your company. It doesn't look like you value your company very well if you don't value your name enough to protect it.
Mm-hmm.
And once you protect your company name and maybe a few product names as well, your company is very, very attractive to larger companies in the same business to acquire you.
Okay. And what costs are involved in getting a trademark?
Well, I will, in my office again, I have a lot of experience, so this may be a lot less expensive if you go to a website like Zoom Legal or Legal Zoom or whatever they're called, although they don't do a very good job. They're acceptable, but they don't do a really good job. I've had some clients come in and have problems with their filings. But I will search 3 names, and please try to make those names creative and different for a set fee of $500. And then if one of those names is acceptable, and I believe, in my opinion, my learned, experienced 28-year opinion, that we can get it through, it will cost you $3,000 to file one trademark application for one mark with either a logo, words, or a slogan in one class of goods or services. If you want to do it in more than one class, let's say you want to do backpacks, which is in the sporting goods class, and clothing like hats or t-shirts, which is in a different class, that's in the clothing class, then you'd have to pay $500 extra for that second class if we filed those applications simultaneously.
Okay. And for those of us considering whether we should do a trademark or not, are there any surprises or anything that I haven't thought of asking that the people who have gotten the trademark, what do they wish they would have known at the beginning? Just a strange way of asking the question. It's one of those things.
I understand it.
What am I not knowing to ask?
Yeah. The most important thing I can stress is if you're going to pick a new name for a new product or a new company, be creative. Don't be a copycat. Don't call your new cola Repsy. There's already a Pepsi out there. Don't be stupid about it.
Okay.
Do something new with a lot of sizzle. Really study it. Do a market study. Even if you just ask your family, ask your kids, ask your grandparents. Do you like this? What do you like about it? Is this cool to your kids? Because you gotta target your audience. Are you selling something for senior citizens, or are you selling something for teenagers? Ask them what they like about it and which one do they like better. And that process is difficult. It's a difficult process because you may like the one they don't like. And I might not like the one you pick. And then you might pick one and I might search it and you might not get it because somebody in Houston's already got it. Mm-hmm. So you just don't know. So if I were to give advice moving forward, I would say spend a lot of time and be really creative about what you name your product, what you name your company. There's a lot in a name. There are terrible names out there. There are names that don't mean anything. Yeah, there are horrible trademarks. When I first heard the name Zelle, I didn't know what they were talking about. I didn't have any idea what they were talking about. But if they had made the quick money exchange or something like that, I'd know what they were talking about. Mm-hmm. And there are other marks that are really good, like Coppertone for suntan lotion. You know exactly what they're talking about. Rapid Shave for shaving cream. You know exactly what they're talking about. It says something about the product.
Yeah. Okay. All right. Well, I believe we have covered as much about trademark as we can at this point. And so Richard, I want to thank you very much for coming on and sharing what you know about trademarks.
I appreciate the opportunity. It's been a good session.
And if people want to contact you, what would be the best way?
You can give out my email address. Email is the best way for me to handle it. I get a lot of calls and I get a lot of texts, and email I can handle. But calls would be a little more difficult. I would say if you send me an email and you're really interested in my services, I will send you back all of my contact information. But for now, I would just like to receive inquiries by email.
Okay, so go to the show notes at reptileentrepreneur.com for this episode, and I will have his email there if you want to contact Richard directly.
And you can also put up my website address, which is patentlawoffices.com.
Okay, I will do so. Richard, thank you very much for coming on.
Thanks for having me, Bill. I appreciate it. Thank you. Bye-bye.
Thank you, Richard, for coming by and talking to us about trademarks. If you are interested in getting some help with a trademark for your company, the contact information for Richard Clark is in the show notes at reptileentrepreneur.com. Thank you for joining me here as we learn the entrepreneurial arts. Take care of yourself, take care of our reptile community, and let's see what we can build.